Hello, everybody. Okay, so we're all here for all handbooks on deck, but I will say that I want to tell a story to explain why I think everybody who is an employer should pay attention, and not just in terms of your handbook. In preparing these materials, I went back to my first trial, which was against Salvation Army. I worked for the National Labor Relations Board, and I represented a woman named Calavita Dean. This was when I represented the government. I wasn't an employer attorney at that point. Anyway, Calavita Dean complained to her employer with a bunch of her coworkers that they were overworked, poorly trained, and underpaid. They brought these complaints to their employer in various different forms, in writing and verbally. The supervisor held a meeting, and basically it was to get the pulse of the employees and figure out what they could do. They were attempting to solve the problem. In that meeting, Calavita Dean was rolling her eyes, she was slouching over, she was being dismissive of the speaker, and the supervisor said, "Do you have something to say?" Calavita Dean said, "I sure do. This is all a lot of talk, but you're not doing anything. And I can't stand it." She got up, she slammed the door, and she left the meeting. She was later terminated for insubordination. So I'm going to date myself. This was way back in the Clinton administration. We won that case. If that case had been heard during the Trump administration, we would have lost. Now we have Biden, and it's probable that she would win that case again, or that we would win that case again. And so it didn't matter that Salvation Army wasn't a union represented employer. The NLRB, or the National Labor Relations Act, represents all employees, period. The National Labor Relations Board enforces their laws against all employers who have at least one or more employees. And so that's why we're here. We're here to talk about how these laws affect us in our business. Oh, do I not have the? Nope.
Okay.
Technical difficulties. I don't have control. Oh, can I steal that? All right, thank you. Sorry. Anybody who knows me knows that this is par for the course with working with me. Okay, so what are we here for? What are our learning objectives? To understand the current state of important labor standards, to recognize what's likely to change under the new administration, and to utilize strategies to adapt to these changes. Okay, so as I have said, the tides are changing. The National Labor Relations Act and the National Labor Relations Board represents your employees. When any party changes, when the administration changes, there is a shakeup of the members of the National Labor Relations Board. There is also a shakeup of the General Counsel, and the General Counsel is there to enforce the rules of the National Labor Relations Act. The Biden administration signaled that very substantial changes with regards to labor law will be coming down the pike. You guys need to know these changes so you know how to prepare. Biden is perceived as the most pro-union president that we've ever had. And I'm not actually sure if that's not true. I think he is incredibly pro-union. The first day of office, he removed the General Counsel and appointed his own interim GC. That is a big signal in terms of his priorities. Although that is standard, presidents do that, they generally don't do it on the first day. It is not a priority, but for Biden, it was a priority. He also stated that it's government's job to remove barriers to workers organizing. And he has put forth quite a bit of documentation signaling his desire to effectuate that. He's given speeches about that. He's very active. So once a permanent general counsel was appointed, she almost immediately started issuing memo after memo after memo, signaling exactly what she wanted to do. So the first one of interest was GC Memo 2104. It issued August 12th. It serves as a roadmap for our priorities, and we're going to talk about these issues. It outlines a variety of issues, including handbook policies, remedies, damages. It identifies kind of a doctrinal shift away from the Trump administration. The next one of interest was 2106, GC Memo 2106. That issued September 8th. And we're going to revisit this later in more detail. We're going to start with the first GC memo, but I just want you guys to know that the reason this one is so important is it advises all regional offices to seek a variety of remedies to ensure that victims of unlawful conduct are made whole, which is pretty much what's standard now. There's a make whole remedy, but it actually instituted and advocated, or not instituted, but advocated punitive damages. This was never part of the landscape. So now it is possible that regional offices will seek punitive damages for things like not posting a notice would be a $500 a day damage. A civil penalty of up to $50,000 for each employee for a violation over the damages awarded for like back pay and things like that. So these memos that signal what their priorities are, what the general counsel's priorities are, and what she wants the regional offices to do are really important. We really need to pay attention. Now, again, they are not law. So what happens is the general counsel signals to the regional offices how they want the regional offices to handle the cases. And then those go up through the system. Okay, so what we're looking at is a shift away in the Trump administration from highlighting employer issues and really kind of kowtowing to employer needs towards a policy that solely benefits employee interests. And I will tell you, it has gone way far to the right, to the left, past the Obama administration. So what we're talking about are major expansions in the realm of protected activity. So it's more than just the right to organize. In that story I told you earlier about my first trial, the reason Calavita Dean was able to bring that charge and challenge her termination was because she was engaged in what's called protected concerted activity. In other words, she and her coworkers were attempting to talk to their employer about something that related to their wages, hours, and working conditions. And so that communication was protected. And way back in the Clinton era, you had to really bend over backwards to lose the protection of that act, right? So you had to, there are cases in which somebody punched their supervisor and then they lost protection of the act. But back then in the Clinton administration, swearing at your supervisor, telling him to F off, wouldn't lose you the protection of the act. That changed through the years. The pendulum is swinging back. So we're changing handbook standards. We're expanding the remedies for violations, but then we're also talking about what's called the PRO Act. And we're going to talk about that in a little bit later. So I'm just going to leave that with you. Okay, so going back to protected concerted activity. How that relates to your employee handbook. The National Labor Relations Act guarantees the workers the right to engage in protected activity, and Section 8 of the National Labor Relations Act prohibits employers from interfering with those activities, right? And the word interfere is kind of nebulous. And depending on where you are in the political spectrum, You either look at that broadly or narrowly. And this is where the handbook comes in, right? So just for context, we're talking about policies related to insubordination. Can Calavita Dean be terminated for slamming a door in her supervisor's face? Issues of confidentiality. Can an employer say to a witness of a sexual harassment charge, I would like you to keep this investigation confidential. I don't want you to talk to the other witnesses or your coworkers about what we've discussed today. Is that a lawful thing to say? We're talking about confidentiality in terms of an employer's documents, an employer's policy manuals, anything that relates to wages, hours, and working conditions, including, can you tell somebody, I don't want you to communicate about this bonus? Progressive discipline policy, can you terminate or write up an employee for being insubordinate? What about disparaging the company? What about using the company's image in their social media? These all relate to an employee's protected concerted activity. So even policy saying you're prohibited from working for an employer who is adverse to the company can be perceived as a violation of protected concerted activity because the courts have said, well, wait a minute, what about if they work for the union? So all of these policies, probably what's going to hit us most close to home, vaccination policies. Can employees get together and say, I won't be vaccinated, I won't wear a mask, and I won't wash my hands regularly? Can they get together and say that? Are they protected? Or did they lose protection of the act? Is it trumped by another more important health issue? By the way, guys, I have a persistent cough, so I have cough drops, I have water. Sorry about that. Okay, so what does this mean? What does Section 7 give you? It gives you the right to organize. It gives you the right to bargain collectively, the right to form, join, and assist a labor union. Excuse me. Other concerted activity, that's where we're really talking about right now. Excuse me. And the right to refrain from all of these activities. Okay, so currently, the National Labor Relations Act prohibits policies that reasonably tend to chill employees from participating in certain activities. This means that policies that don't outright violate the right to protected activity still violate the NLRA if an employee could reasonably construe them as a violation. So anything that might interfere or might be thought of to interfere with protected concerted activity is banned. Okay, so that was pre-Trump, by the way. That made it a big challenge to do things. That made it a big challenge to write your handbook policies. That made it a big challenge to enforce your rules regarding respectability, regarding respect for coworkers and supervisors. Employers were really chafing under this rule. So think about all the things that could reasonably tend to chill an employee from getting together with their employees to talk about wages, hours, and working conditions, to talk about how they feel about the vaccination policy, how they feel about the COVID policy, how they feel about the work from home policy. So do they have access to the employee's email system? Do they have access to the bulletin board? All of these things were perceived as reasonably tending to chill. And regardless of how tenuous. So in the Trump administration, the NLRB expanded the possibilities for these handbook policies. The most significant case that really kind of changed the whole landscape in the Trump years was a case called Boeing, and it changed the employer justification, and it allowed employers to put forth their legitimate reason for making the policy. So for instance, if you are making a policy about insubordination or respect, you could basically say, well, we need to have this respect so we can have good relationships with our employees. And the board would rubber stamp that. All the workplace rules that we discussed, confidentiality, non-disparagement, social media, media communication, civility rules, all of those things got a pass in the Trump administration. The way he looked at things was, or not him, but the way the board at that time looked at things, where they created a category of handbook policies. And those that didn't interfere with the rights of protected activity were categorized in section 1. And those were always okay. Those that may interfere with the rights of protected activity but could be justified were put in category 2. And what they ended up doing is they created this case law, which almost universally accepted those things in category 2 and eventually kind of filtered those things in category 2 over to category 1. So really, 2/3 of the things got shifted over to always okay. And then you had those things that outright violate protected activity. And those were always a no. So the things that ended up in always the no category was you can't have a policy that says that prohibits employees from discussing their salary. So it was a very discrete small group of things in comparison to previous case law. So again, what you had with Trump is the employer justification almost always trumped the employee interest. What Biden is doing now and what the General Counsel is attempting to do now is to shift that seesaw back and forth so employee interests are predominant. So let's look at some of the policies we're talking about. Be respectful to the company, other employees, customers, partners, and competitors. When I started with the board, this was an illegal policy. Under Trump, it is now legal. Biden will probably knock that back down because, and the justification is, folks sometimes are disrespectful when they're talking about their wages, hours, and working conditions, and we have to expect them to be able to vocalize their frustration. Do not make embarrassing, insulting, hurtful, or abusive comments about other company employees online, and avoid the use of offensive, derogatory, or prejudicial comments. So again, the Trump board says that's okay. Biden will probably revert back to the Clinton era in which those policies will be illegal because it prohibits an employee from discussing their interactions with a supervisor in a way that is perceived as offensive, which means an employee can't say, my supervisor is a jerk, which was previously believed to be protected. You must not disclose proprietary or confidential information about the employer or associates if the proprietary or confidential information relating to the employer or associates was obtained in violation of the policy, of a lawful policy. So this one, I think we're going to see how it shakes out. If they didn't have the last portion that said which was obtained in violation of the law, it would definitely be a no, because if an employee has access to employee data, such as employee policies, those might be protected. Those might be perceived as confidential, but they are allowed to hand those off to anybody they want. They can post it online. They can discuss it with their coworkers. They can complain about it. And so whereas in the Trump administration, again, this would have been perceived as fine, we're probably going to revert back. Employees who interact with customers may not wear pins, insignia, or other message clothing. This would be perceived as preventing employees from wearing union garb. Employees may not engage in solicitation for personal endeavors or commercial purposes on company property. The Biden administration would see this as keeping employees from handing out union cards, discussing the union, or serving as a union rep. So all of these things will most likely change. Probably, again, the most important thing that will change is the General Counsel stated in the first memo she issued that any employee complaint or discussions about a healthcare issue will be protected. So in order to receive the protection of the act, it has to be something about a wages, hours, and working conditions. And so the General Counsel said categorically, if it is about health, it is about your wages, hours, or working conditions. So you don't have to try to prove that element. So this includes protests against the vaccine, it includes mask protests, all of that stuff. So what do? How do you prepare for this? I mean, the first thing I would say is don't get caught off guard. I'm super glad you're here so we can talk about this. We can kind of flag this for review. You know, make sure that you start planning now for these things that will come. You know, when we first started drafting this, when Brian put out all of the marketing materials, you know, we started drafting this and I had to edit it this morning because it had changed so quickly. Because one of the things that we anticipated would happen, in fact, did happen. And so we had to react on this presentation. So when I tell you things are happening quickly, it's really much quicker than I have seen in my 20-year labor career. They're very effective. It is an incredible priority for this Biden administration. And he is, his soldiers are acting fast. Okay. Until changes are made, you still have the right to enforce the previous era's rules. So all of your handbook policies are currently okay. That said, everybody has to be that first case, you know? So if you think that you recognize any of these policies that we've just discussed, you're going to want to reevaluate them. You're going to want to sit there and think, okay, how would the board shake out if they get their hands on this policy? And do I want to make changes in advance? Know that there will be a time when your feed will blow up with the first case of a disrespect case, the first confidentiality case. And at that point, you're going to have to amend your policies. Okay, so this is what we have to do. We have to amend our policies. We have to think about our policies. We have to anticipate how they're going to act. Why do we have to do that? One of the reasons is they are changing the standard of the remedies. Before, and in fact, during my entire 20-year career, so even back when Clinton was leading the charge, there were make whole remedies. So in other words, if somebody had been if an employer had been accused of an unfair labor practice, they knew what the damages were going to be. They were capped at make whole remedies that would restore the employee to the position that they would have been in had the violation never occurred. So it included back pay, it included benefits. In very rare, strangely enough, rare occurrences, you had front pay. That was actually not super common. Now, the GC memo encourages utilizing every possible tool we have to ensure those wronged by unlawful conduct obtain quote unquote true justice. So what's the translation? Employers will have to pay much higher penalties. According to the memos, monetary remedies, back pay, front pay benefits are often not enough to make up for the violation. So what are they looking for? They're looking for punitive damages. And this is new to the National Labor Relations Act. They're looking for things like we discussed before, if I'm sure the posting will be cleared. And if you're not posting, you owe $500, per day. Civil penalties of up to $50,000 were proposed for each violation as an award to the employee. So in all of the cases that I had before the NLRB, the employee was awarded back pay, but they weren't awarded an additional fee or an additional penalty for bringing this claim. They didn't get anything on in addition to what they lost. And the GC is signaling that that's what they want. Not signaling, telling us that that's what they want. So in addition to the penalties, they're also going to help unlawful conduct during, they're also going to help organizing drives. So if there's unlawful conduct during the union organizing drive, they're going to make it a lot easier for unions to get a hold of your employees. They're going to give contact information. They're going to reimburse organizing costs. They're going to now oftentimes if there's a violation when there's an organizing drive, notice is sent to the employees or posted in a place that the employees see, like the employee break room. It's very rare that the employer is obligated to read the posting in front of the employees, but that will become more mainstream. And then, of course, if you're really in a pickle and your union is entrenched and won an election, you have failure to bargain issues. And the NLRB has said that they're going to institute bargaining schedules, submission of progress reports, reimbursement of collective bargaining expenses. Now, hopefully none of you will be in that position, but these are all things that we need to think about. Oh, I messed up the graphics. I'm sorry, guys. Okay. So how do we prepare? Same thing. We monitor the practices to ensure compliance. You just really want to make sure you keep an eye on it. Talk to your labor lawyer. If you don't have a labor lawyer, get one. And this is a bias on my part, but if you have an employment lawyer who says that they do labor, ask them questions. Make sure they actually know what they're doing, because we used to make fun of employment lawyers all the time who came in and tried to practice labor law. Have a labor lawyer. Stay up to date with the remedies. Be aware of what different remedies are and what they entail. So be aware of all of these things and make sure you have counsel who is aware of all of these things and knows what's going on at the NLRB, because you do want to adhere to these. Biden doesn't just want to increase union organizing. He wants to bring the National Labor Relations Act to non-union employers. Okay. And to just bring that issue home, let's talk about the PRO Act. So what is the PRO Act? The PRO Act is the Protecting Right to Organize. This is a drastic change. Okay, so let's just talk about first things first. Kentucky and 20 other states are right to work states, meaning an employee cannot be fired for not paying union dues, for refusing to join the union. This law has been successful these laws, because they're state laws, have been successful in reducing union organizing, because unions don't want to represent a bunch of employees who don't pay them. And if an employee doesn't have to pay a union, why would they, right? So it totally makes sense. The PRO Act is going to ban these, or wants to ban these. The PRO Act would mandate employers give employees access to emails for organizing, engaging in protected activity. So you would have to allow your employees to have emails to talk to other employees about how much they hate the vaccine mandate, how much they hate the mask mandate, how angry they are at you versus about every little thing that relates to their wages, hours, and working conditions. This bill makes it, or would make it, an unfair labor practice to require employees to attend certain employer meetings. Prohibits agreements in which employees agree to waive their right to pursue or join collective or class actions. I mean, I don't know about how your agreements look, but if I ever have an employment agreement, I put something in there that says, if we have a conflict, you're not going to bring a class action against me. Those would be banned. It would allow gig economy independent contractors to unionize and bargain collectively. So these folks will now be employees or considered employees for purposes of the act. And we actually saw something that is similar. I don't know if you guys noticed, but now college employees or college athletes are considered employees under the act. That just came out. So essentially, this is the same thing. These are all ways of increasing the fold of folks who are subject to the National Labor Relations Act. Okay, so how do you prepare? Going back to how do you prepare? Oh, my pages are stuck. Sorry, guys. I know. I forgot to mention the thing that was not on the slides, but that I had to put in is Labor Day. Biden gave a speech in support of organized labor and the PRO Act specifically. He announced a task force called Workers Organizing Empowerment and asked that Vice President Harris and Secretary of Labor Walsh serve as chair and co-chair. So he created this task force simply to enforce this, right? And then, fearing the PRO Act wouldn't pass, Democrats on September 8th released a new pitch to introduce components of the PRO Act in the budget reconciliation package that we all hear about every feeling darn day. Okay, so going back to what to do. You got to know about the contents of the PRO Act. Find somebody who knows about it, talk to them, figure out how it affects your business. Take stock of your current practices and know how you will be affected. And again, consult an attorney. And I cannot stress this enough, a labor attorney, not just an employment attorney. Okay. Now, those are the biggest, scariest things that we're dealing with. The rest are all kind of small fry priorities, but I think that they are worth mentioning. How are we doing on time, by the way?
Got about 14 minutes.
Okay. Okay, so Weingarten rights. Weingarten rights are the guarantee that an employee has the right to a union representative in an investigation. Weingarten, I don't know if I have a graphic for this, so I'm gonna, oh yeah, I do. Okay, Weingarten applies only to union employees. Back in the day, when I was a new labor attorney, there was something called epilepsy rights. And epilepsy was a case that allowed Weingarten rights to be expanded to non-union employers and employees, which meant that if you brought your non-union employee in to discuss a disciplinary issue, he or she would have a right to say, I don't want to talk about this with you without a witness present. And you would, by law, be obligated to allow her to have a witness of her choosing present during that interview. So this is kind of a big deal. I haven't heard any murmurings of epilepsy coming back recently. That said, it is a favorite of, I'm sorry, pro-labor folks. So I wouldn't be surprised. Hang on. Oh, okay. There's likely going to be conversations about whether NLRB has jurisdiction over employers with religious institutions. Hang on. Okay. This cough is a bear, y'all. That case I told you about before, it was against the Salvation Army. We won in court, but it was overturned because Salvation Army was perceived as a religious institution. This will probably be revisited. I have no idea how this will shake out. We have a very pro-religious institution Supreme Court. So I wouldn't be surprised if religious institutions were rolled in and then that got knocked out by the Supreme Court. Protections for undocumented workers. Back in the day, undocumented workers were protected by the National Labor Relations Act. They were allowed to get back pay. They were allowed to bring suits. That changed. I suspect that will swing back. Okay. My God. Conclusions, staying afloat. Okay. So again, just to reiterate, what do? Don't get caught off guard. Stay up to date. Consult an attorney. Oh, I like these little graphics. Okay, this is a good place to stop because I've been coughing like a crazy person. So I'm going to check and see if you have any questions. And where are we?
Yeah, we have 10 minutes left. We have a question. If you live in an at-will state, how would Section 7 apply here?
Okay. So what an at-will state means is that pretty much almost everybody is an at-will state. So the National Labor Relations applies to all states, period. It's a federal law. What it means to be an at-will state is that you can terminate your employees for any reason or no reason at all. It just can't be an illegal reason. And so the National Labor Relations Act can be one of those illegal reasons. If you have a union, what would happen is a union contract would come in and change the at-will status of your employees because they would now be subject to this collective bargaining agreement. But that's true across everybody, across every state. So it really doesn't, it's not an issue of whether you're an at-will state or not an at-will state. It's the only issue that would affect it is if you're a right-to-work state. That's it. That's all the questions. All right, I might let you guys out easy.
That's it.
All right. Well, thank you guys so much for showing up. Thank you for caring about this subject, and I wish you all the best.
All right, and just a plug from the McBrayer marketing team, we have one more webinar coming up. It's Scary Stories from the HR Department, Part 4, Little Shot of Horrors, taking place on October 27th. If you look at our marketing materials, there'll be links to that there. Also visit www.mcbrayerfirm.com for more information, and we hope to see you there. Thank you for attending today.
Thanks, y'all.
And we'll be sending out an email with the video and the slides sometime this week. Thank you.